Okay, we're going to go ahead and kick this off. So if everyone will grab your seats, I think we got a lot of Southern Baptists in the room. There's no one sitting on the front pew here, but you're welcome to move up here. I promise you we don't bite that much. But I want to welcome everyone here today to talk about something that seems somewhat esoteric and that the general public probably doesn't talk about when they're sitting around visiting with their family over turkey at Thanksgiving. But this is an issue that many of us in the legal community and in state governments have to deal with. So what we're here today to talk about is the current state of climate change litigation, but more specifically, the municipality's role in driving that litigation. Now, we can talk about climate change in terms of municipalities bringing lawsuits within the energy sector, but this, with the recent opioid litigation that's going on around the country, I think we're now somewhere north of 2,000 to 2,500 municipalities that have been engaged, who have engaged by plaintiffs' firms to bring lawsuits. And there's an old saying in our office in the state of South Carolina that the state is the state is the state. And so we're going to hear today about the current status of a lot of this litigation that's going on as it relates to climate change, as it relates to public nuisance laws. We're also going to hear about some of the implications and ramifications of municipalities, for the lack of a better term, weaponizing local public nuisance laws to drive national and international policy as it relates to the broad playing field of the country. And we can talk about what motivates municipalities or what motivates plaintiffs' firms, but regardless of what motivates and what their intentions are, it's creating a real issue, especially when it comes to trying to have global settlements on very complex cases that have far-reaching and ranging impacts in our respective states and communities. I am sitting up here today. First off, for those of you who don't know me, my name is Alan Wilson. I'm the Attorney General from South Carolina. I was just elected to my third term last year, and now in my 9th year as Attorney General. So I've been around long enough to kind of see how these impacts affect people. Before I introduce our distinguished panelists today, I'd like to thank the Rule of Law Defense Fund and its staff for putting this panel on. You can see them over my head. These kind of forums and these public policy discussions and forums could not happen without our staff, and I want to single out Pete Bisbee and the team up there for putting this together. I've read the bios, and I've had a chance to talk with our panelists both a week or so ago on the phone and again today, and it's a pretty remarkable group. And I'm a little intimidated because there's a lot of brain power up here. But I'm going to go ahead and tell you a little bit about our panelists, and then we're going to go ahead and kick it off. First, I would like to introduce Andrew Grossman, the partner with BakerHostetler. Andrew is co-leader of the firm's national appellate practice. He advises members of Congress on matters of constitutional and administrative law, having testified more than a dozen times before the House and Senate Judiciary Committees. He's been a frequent legal commentator on radio and television, having appeared on national networks like Fox News, CNN, MSNBC, CNBC, NPR, and its affiliates. His legal commentary has also appeared on dozens of magazines and newspapers, including the Wall Street Journal, USA Today, the Washington Post, the Washington Times, and many others. He is an adjunct professor at the Cato Institute's Robert A. Levy Center for Constitutional Studies. He's a member of leadership in the Federalist Society, and previously served as a fellow and policy analyst at the Heritage Foundation's Meese Center for Legal and Judicial Studies. He clerked in the Fifth Circuit United States Court of Appeals early in his career. So I want to thank Andrew Grossman for being here today. You'll also be hearing from Phil Goldberg, managing partner of Shook, Hardy & Bacon. And before I go into Phil's bio, I want to say that I am pulling out highlights. I'm giving you guys the movie trailer because I want to give them the bulk of the time to talk. So they've done a lot more than what I'm reading. Phil Goldberg has more than 25 years experience on liability-related public policy, public affairs, and public relations issues. He counsels Fortune 500 companies and their trade associations on a wide variety of liability public policy issues. Phil focuses his practices on 3 areas: development of the common law, federal and state legislation, litigation, communications. As co-chair of Shook's Public Policy Practice Group, Phil has filed amicus briefs with courts at every level from the U.S. Supreme Court to the U.S. Court of Appeals and state appellate courts. In 2015, he was named the director of the Progressive Policy Institute Center for Civil Justice, which provides a center-left voice on important civil justice issues. With respect to government litigations and public nuisance theory, Phil has become a leading voice for maintaining the traditional boundaries of the tort and not allowing it to become a catch-all theory of liability. He has also authored amicus briefs submitted to the U.S. Supreme Court in the 2011 climate change case, Connecticut v. AEP, and the Supreme Court of Rhode Island and Rhode Island v. Lead Industries Associations. Moving on. I'm sorry, Phil, you have a long bio.
Please stop. Honestly,
I was like, I remember taking down more information on you.
my mom is not in the audience. You really can go on.
Let me read the most important thing about you that you put on here. He resides in Bethesda, Maryland with his wife, 3 kids, and their fun and energetic dog, Riley.
Thank you.
That's the most important part of your bio, right? All right. Next, we have Professor Donald Kochan with Chapman University School of Law. He was the Associate Dean for Research and Faculty Development at Chapman Law from 2014 to 2019. His teaching and scholarship focus on law and economics, constitutional law, property law, tort liability and remedies, administrative law, and environmental and natural resources law. He has published more than 40 scholarly articles in these fields. He's also been cited in dozens of books, as well as 400 scholarly articles. His commentary and analysis of climate change, public nuisance litigation, has recently appeared in the LA Times, the Washington Times, The Hill, Investors Business Daily, and Real Clear Politics. He clerked in the U.S. Court of Appeals for the Sixth Circuit and was an associate with the law firm of, I don't want to mispronounce this, Crowell and Mooring, LLP in Washington, D.C. And let's see. Finally, we have Walter Olson, senior fellow at the Cato Institute. Walter is a, as a senior fellow at the Cato Institute, Robert A. Levy Center for Constitutional Studies. He is known for his writing on the American legal system. His books include The Rule of Lawyers on Mass Litigation, The Excuse Factory on Lawsuits in the Workplace, and most recently, Schools for Misrule on the State of the Law Schools. His first book, The Litigation Explosion, was one of the most widely discussed general audience books on law at its time. It led the Washington Post to dub him the intellectual guru of tort reform. Before joining Cato, Olson was a senior fellow at the Manhattan Institute and an editor at the Magazine on Regulation. I could keep going on and on and on, but I feel like I've already taken up enough of my time. I think I've qualified all these guys to be experts if we were in court right now. So I want to go ahead and kick this off with Andrew Grossman. Andrew, I'd like you to give us the current landscape of climate change litigation and highlight for us how courts could possibly solve these legal questions.
Thank you very much, and thank you to the Rule of Law Defense Fund for hosting this event and for inviting me. It's a very important topic. Before we turn to the current status of the municipal climate litigation, I'd like to pull back a little bit and sort of paint a picture for you. The Norwegian Sea is a cold and desolate body of water to the northwest of Norway and adjacent to the Arctic Ocean. In a particularly bleak corner of the sea, 93 miles due west off of Norway, a concrete structure resembling a thumbtack juts out of the water, rising over 100 feet into the sky and breaking the otherwise unmarred horizon. This is the production platform of the Draugen oil field, operated by Norsk Shell, a subsidiary of Royal Dutch Shell. It is an engineering marvel. Its single piling plunges down 800 feet into the seafloor, where it's surrounded by storage tanks. Those tanks are connected to a loading buoy, and that's used to transfer the oil to tankers. The oil is then transferred to a shore terminal and then to refineries in Norway, Sweden, or in some cases the Netherlands. And then the refined products are sold into the European market. So a question, whose law regulates the carbon emissions associated with the oil produced from Draugen? Is it Norway, because Draugen is in its exclusive economic zone? Is it Sweden, because much of the Draugen oil is refined there? What about the Netherlands, where Shell has its headquarters? Or maybe the UK, where Shell is incorporated? Perhaps the European Union? Or is at New York City, which in 2018 sued Shell over the carbon emissions associated with its oil production, including the oil produced from Draugen. The New York lawsuit is one of about a dozen filed by US municipalities against energy companies to obtain compensation for climate change. Other lawsuits have been filed by San Mateo County, Marin County, Imperial Beach, San Francisco, Oakland, Richmond, Santa Cruz, and Santa Cruz County. That's just in California. In Colorado, there's Boulder City, Boulder County, and San Miguel County. And then in Washington State, there's King County, and over here on the East Coast, Baltimore, Maryland. These suits are brought under several legal theories. Most include state law claims for public nuisance and trespass, and some also have negligence claims. A public nuisance claim in general is based on some kind of interference with a right of the public. And so typically it could be something like excessive noise from a factory, offensive industrial odors, or perhaps a concrete plant that blankets a neighborhood with dust. The trespass claims in these suits are generally based on the theory that rising oceans are entering places like San Mateo without their permission. At least one of the suits, the one filed by Boulder, alleges a conspiracy to mislead the public about climate change. All of the lawsuits allege that fossil fuel production is wrongful, and that as a result, the municipalities are entitled to money damages. I should note that none of these lawsuits are limited to conduct that occurred within the jurisdiction of the municipality bringing suit. So when they go after Shell, they're using litigation to reach and to regulate Shell's oil production in Draugen. So far, 3 of the municipal suits have been dismissed. When he dismissed the San Francisco and Oakland cases, Judge William Alsup explained that declaring something a nuisance and putting a price on it is exactly the same in economic terms and legal terms as regulation. And he continued, the courts don't have the power or the ability to regulate global energy production. The other suits remain pending, but so far none has achieved any real success. These lawsuits raise many serious questions, and in my remaining couple of minutes, I'd like to try to identify a few of the most important ones. So first, if, as the Supreme Court held in AEP versus Connecticut, the Federal Clean Air Act speaks directly to carbon emissions, then aren't all of these state law claims obviously preempted by the Clean Air Act? What, if anything, has changed since 2011 when Connecticut and other states abandoned their state law nuisance claims against energy companies after the Supreme Court rejected their federal law nuisance claims? How can conduct like energy production that is specifically authorized and encouraged by law be a nuisance? Why are the energy companies even the right defendants? Why not the actual emitters? Why not the automakers, the airlines, the electric utilities? Why not the end users of fossil fuel products, the people who drive the cars, fly in the planes, plug in their cell phones at night? Is everybody liable? What about the federal government? It has a lot of emissions. Aren't the municipalities bringing these suits themselves responsible for some amount of carbon emissions? How is a court supposed to apportion damages? And if liability on a nuisance claim is a determination that emissions were excessive in some respect, then how is a court supposed to determine the acceptable and lawful level of emissions? Would the court have to determine the right target for atmospheric carbon dioxide concentrations? How would it even begin to do that? What law does it apply to arrive at the result? What if Congress or the EPA disagrees? What if the United Nations disagrees? What if another court disagrees and chooses a different level? Wouldn't the court have to take into account the benefits of fossil fuel production to determine liability? If access to energy saved 1 million lives in sub-Saharan Africa last year, how does that factor into the calculation? What is a US court supposed to do about something like the oil production in Draugen in Norway? Is a US court seriously going to override Norway's policy choices and its laws on energy production? Should the court take into account what Norway is already doing with respect to emissions and climate change? Should the court ask Norway what it thinks about all of this? Would there be some kind of bilateral summit between the trial judge and the Norwegian ambassador? What if Norway threatens trade sanctions in response to a judgment against Shell? Does the court hold Norway in contempt? Or should the court follow the law against extraterritorial application of US law, as well as the doctrine of comity, and refuse to meddle with energy production outside of the United States? If so, wouldn't that wipe out something like 86% of potential damages immediately based on the proportions of emissions? And that's even before you look at the conduct of particular defendants. Or maybe the line should be drawn to exclude activity outside of a particular state or municipality. At that point, wouldn't the damages approach, I don't know, zero? Now, I may have my own views about the answers to some of these questions, but I'm even more curious about what the plaintiffs in these cases think the answers are. They brought these suits, and the burden is on them to explain how all these cases are supposed to work. Have they given it any thought at all? Or are these lawsuits just a roll of the dice? And for now, for this moment, that will be my final question. Thank you.
Thank you very much for that. Walter, I'd like you to kind of go to the bigger landscape or the big picture on mass tort and social change litigation, kind of give us what's going on at the broad level.
Well, sure. This is, of course, not the first time that we've seen this script. And you mentioned the opioid litigation, which recently in the state of Oklahoma culminated in a 9-digit verdict from a county judge applying Oklahoma's relatively liberal and broadly drafted state law on nuisance. But it didn't start with opioids either. We can look back 20 years ago to when the nation was convulsed with the debate about whether the gun manufacturing industry should be brought down by a variety of municipal suits which had been, like these, urged on the municipalities by contingency fee lawyers, and many of which invoked nuisance theories, then more novel than now, and claimed that by flooding the market with various weapons, manufacturers, even manufacturers that specialized in police and military supply, were still said to be flooding the market to those recipients, were all, as a result, responsible for the damage done by guns in American cities. Now, nearly all courts, in fact, rejected those gun nuisance suits, and we never found out, because of the Protection of Lawful Commerce and Arms Act, passed in the late 90s, we never found out whether the plaintiffs would have succeeded in their strategy of losing 19 out of 20 cases, but bringing the industry to its knees by the leverage of the occasional breakthrough case where they got lucky in some way or other. But this wider pattern has been going on for a while. They don't have to make the law stabilize at a new point. They just have to win occasional startling victories and extract a settlement because of it. Now, if I may use my phone to update us on some of the very newest nuisance news, that's an awkward phrase, isn't it? I wanted to bring you the latest from Oklahoma because it made me smile, and not much about this litigation makes me smile. The headline is, Oklahoma judge says he miscalculated award in opioid case by $107 million. It's just, you know, it can happen when you're working with a pencil and paper. And his overall verdict, his award against Johnson & Johnson was to pay the state $572 million. And the judge has now come back in a hearing in Cleveland County and said, never mind as to at least $100 million of that, because he said he had intended to award $107,000 to a program that helps the state develop treatments for babies born addicted to opioids, and he had accidentally put in 6 extra zeros at the end of it, turning it into a $107 million component of the, now that he recognized the mistake, he would back that $100 million or so dollars out of it, and he jokingly told attorneys at the end of the hearing, I'm sure they were smiling, quote, that will be the last time I use that calculator, unquote. So I'm not making this up. So it is with this confidence that we turn to forum shopping and the results of clever lawyering to solve some of the most difficult and issues with which our society is grappling, whether it be the addiction problem or the problems of global warming. I don't have great confidence that nuisance law is the right way, and Andrew has stolen some of my argumentation, but not all of it, because it's worth going back historically to why it was that the courts of England created nuisance law, allowed it to go forward for hundreds of years as a small, defined, but usable area of law. It was typically over direct neighborly relations. You could sue over noise, perhaps. You could sue over smoke. You could sue over animals that were being allowed to roam from their owner and chased or bit people on your property. Occasionally, there was a bit of a metaphor. You could sue over bawdy houses, for example. Even though they weren't doing that, they were still leading to neighborhood effects that led to things going wrong in your yard and on your property. And what you could not do, on the other hand, was to sue over things that either affected the entire public or whichever one did. Now, a good example of that was smoke. You could sue over unusual sources of smoke, as if someone had put a smelting plant right next to a residential neighborhood. You could not sue over chimneys in the era, relatively recent, speaking of energy, in which everyone had chimneys because everyone needed to use them to keep warm. The courts would be, at best, wasting everyone's resources if they attempted to entertain litigation over an activity from which everyone benefited and to which everyone contributed part of the nuisance. So, no, you could not sue over common activities that you had benefited from and that were widely done by your neighbors. That's not what nuisance law had been about. Much less was it about being able to sue over the smoke from chimneys if you were trying to sue, let's say, the supplier of firewood 10 miles away. You had to sue over the direct cause of the nuisance, which meant the person with the chimney, not the person who'd supplied the firewood. So all of this kept nuisance law cabined in an area where courts could keep an eye on it with a mind to the well-being of the community, typically a single community in which both ends of the litigation arose. And when they began battering away at this, and I have to say, I smiled at an article in the Washington Post a few days ago which portrayed this folksy lawyer in West Virginia who had decided to sue opioid companies over addiction problems. And it made it sound as if he had come up with this idea because in the homespun wisdom of his community, you needed help for your neighbors. No, this was all hatched in very high-powered lawyers' offices 20 years ago. You don't need to pretend that it's been invented recently. And yet, they love these stories. They love to spin these tales. Two points that I want to get into before I finish. One is why this is not easily cabined, and secondly, this is why the business community generally outside the area of energy defendants and opioid defendants is watching with terror how this develops because it can expand in so many additional ways. Think of these questions of who can sue and who is responsible. Attributing responsibility is almost impossible for reasons that Andrew got into, and in this case, of course, we have fun precedents from the gun case. When the gun suits were presented, the industry was demonized. Many of you in this room know how that works as a process. And then people got to work digging, and they discovered that the cities of Detroit and New Orleans, both of which had filed these suits over alleged overproduction and dumping, were themselves the largest suppliers of firearms in their regions because of all the police surplus, not just guns formerly used by police, but guns seized from wrongdoers at scenes. And Detroit and New Orleans promptly resold this for profit onto the private market, flooding the local markets. And even though they were arguing in their lawsuits that any ethical person would have attached gun locks before selling, they had not done this to any of the guns that they had themselves sold. So the hypocrisy helped sink the suits. And beyond that, there was the problem, which remains in the opioids case, and which Andrew also mentioned with regard to the energy case, of either you are asking for the correct level of conduct to be zero, in which case you have one kind of problem, namely, how does the court take into account the amounts of starvation and other human misery had production actually been zero. Or if you're not arguing that, then you have to argue excessiveness. And if you argue excessiveness, your problems multiply when you get down to a defendant who has 3% of the market. It is argued against opioid makers who have 3% of the market, as it was argued against gun makers who had 3% of the market. When you sold twice as much this year as you had sold 5 years before, you should have known you were flooding the market. Well, the ordinary business plan, shocking as it may seem, of serving all orders that come in the door does not usually involve a pause for an ethical stage of, wait a minute, isn't it suspicious that orders from us have doubled? Because it's so easy to assume that people like your product enough that your market share has gone up from 3% to 6%. It can be very hard to tell that that is not the reason why your sales have doubled. And it was considerations of this sort that caused the courts, even very liberal ones like Illinois and New York, to reject gun nuisance, which are currently causing the rejection of many of the energy nuisance cases, and which I predict and hope, should the opioid cases wind up going all the way to trial rather than settling, though there is some reason to think they will settle, should result in the dismissal of the opioid nuisance cases as well. Should that not happen, watch out alcohol makers. Thanks.
Thank you for that. I'd like to now turn to Professor Donald Kochan. Talk to us about the separation of powers issues that have been created through this litigation, and kind of expound on that a little bit, and then whatever else you want to talk about.
Thank you, and thank you to the Rule of Law Defense Fund and everyone for coming today. We've seen here this expansion described to you, and part of what I want to talk about is why is that happening, and what should we know about the dangers of moving to the courts to actually try and resolve many of these things. So first, why is it happening? I think there's an over-reliance on the court system to solve social ills, in part because we are frustrated with our political institutions. We are frustrated, or individuals who want to solve some of these problems are frustrated with gridlock in Congress or state legislatures, and an inability to find solutions in those places. Unfortunately, that has led people too often to set aside the institutional restraints and constitutional limits that indeed are protecting a variety of both individual liberties and also sound policy. And so by throwing out the institutional limits, simply out of expediency to try and solve social problems, people forget about why courts should be cabined in their authority and why legislatures should, in fact, be the policymaking arm of this. Without it, we cannot have a defense of the rule of law. Without it, we cannot protect the rule of law, which requires that people be able to identify the source of lawmaking authority, that they be able to predict how laws are going to be set, that they be able to adjust their behavior on the basis of pre-existing duties. And if you don't have that coming out of a legislature, but instead you have it coming out of retroactive liability from a court based on an expanded doctrine well beyond its common law limits, as we've already seen, and that really has no limiting principles and is shape-shifting over time depending on what the social ill is, we cannot, in fact, adjust our behavior in a way that would be fair and provide fair notice to individuals in the system of due process. So, in that sense, we've always thought that the courts are to be of limited authority to identify pre-existing duties and to enforce those, but not to make law or create new doctrines that, in fact, expand liability quite substantially. So one reason I think that we've gotten to this is the desperation that we see in the face of gridlock in legislatures. And I've seen people actually admit that are bringing some of these suits that, well, we can't get it out of the legislature. I'm going to talk in just a moment why I think that we should nonetheless turn back to the legislature and regulatory agencies if, in fact, we want to solve any of these problems. The next point of desperation is funding. And that is, especially in a lot of these public nuisance suits, some of them are going to individual plaintiffs, but some of them are going to abatement funds. And so this idea that cities cannot solve the social ills that they are faced with without substantial funding means that they are looking for deeper pockets. They're looking for individuals who can fund what should be traditionally social programs funded by the public fisc, that no one person alone should bear burdens that should be borne by the public as a whole. is a concept that we've understood in our takings clause, that we've understood throughout our history, that we should not be placing burdens on people simply because they have the ability to pay to solve our social problems. So the need for funding is another thing that's driving us toward the courts, especially when these municipal legislatures or municipal entities don't have the funding themselves and don't want to tax their citizens to solve these problems. They'd rather tax those businesses who have been contributing to the economy and without regard for the potential economic consequences. So, and then the third thing is that we have individuals who are self-interested, right? We have individuals like plaintiffs' attorneys who, instead of the person who just comes up with this idea in West Virginia, we have an organized driving force, and I think Phil's going to talk a little bit more about that as well. And that is, this organizing driving force is actually going and soliciting and encouraging individuals to disregard our constitutional limits. So let me talk about those constitutional limits from two perspectives. One, why we have constitutional limits from a sort of instrumental perspective, and then why the separation of powers has additional constitutional ramifications. So the first is about comparative institutional competency. If we accept that there may be a need to address climate change, then we should be thinking about who is best equipped to do that. And I think Andrew started off with a ton of questions, which are the kind of questions that legislatures need to consider. How should we apportion this kind of liability? Who? What kind of expert evidence do we need? How can we balance competing interests? These are things that belong in a legislative deliberative process. These are things which require the interrogation of experts by rulemaking agencies. These are things that require public participation like we expect in our rulemaking processes at the regulatory agencies, in which all affected parties can have a say in the ultimate rules that are generated as a result. That's why we have notice and comment rulemaking for regulatory agencies. That's why we have displacement that Judge Alsop is talking about, that in fact the courts have been displaced by legislation over time, and we should leave room and space for them to continue doing that. So legislatures and expert agencies are in have a comparative institutional advantage at dealing with these kinds of complex problems that require intense scientific examination, deliberation based on competing considerations, understanding the benefits that come from things like energy production and the cost of limiting it, including the cost to activities which individuals that some of these plaintiffs may actually prefer be protected. From a comparative institutional competency standpoint, courts are just not well equipped to do this. Judges are not scientific experts. They're not ones who can evaluate scientific expertise. They cannot solve complex problems like this. That's why we turn to others. The fact that the legislature may be doing a poor job in some plaintiffs' estimation at doing that is not a reason to ask the judges who are not well equipped to do that to do it instead, right? Simply because your plumber is doing a good job, you don't call your gardener inside and ask him to start doing the plumbing, right? And so we expect our judges to be the ones who are deciding cases, real cases and controversies, identifying pre-existing wrongs. We expect legislatures and regulatory agencies to be addressing the bigger complex issues. Now, from a pure separation of powers standpoint, we also have committed those tasks in the Constitution to the legislative and executive branches. They are the policy-making wings of our constitutional system, and we ask that judges only interpret laws, not make them. And what's necessarily required, and I think that is also clear from Andrew's opening list, is that if a judge is to entertain these cases, whether it be a federal or a state judge, they must transcend their boundaries of the judicial process and start making policy decisions, start making policy choices, making policy calls, deciding what the level of appropriate emissions will be. And those are not things which we have entrusted in the Constitution judges to do. Judges should say what the law is, not what it should be, and we should ask that those lines be protected. Those lines are protected for a reason. They're there because judges, if we allow judges to make policy decisions, they can make just as many policy decisions we prefer as they can that we dislike. And one of the questions I would add to the list to ask the plaintiffs in these cases is, would you be satisfied if we allowed these cases to go forward and a judge declared climate change is not a problem, it is not real, and it is not man-made? If a judge were to make those pronouncements, would that be acceptable? It would seem to these plaintiffs they probably would not like that result. Yet that result would be ingrained in a fact-finding mission by a judge, declared from on high by a court that this is the truth. And yet that would not be where they think these cases should be going. So there's a presupposition that the judges are actually going to accept the underlying premises of the litigation, but we could very well see a judge that would go in a different direction. And if they did, that's the kind of danger in giving it to judges, because judges, especially federal judges, have very limited accountability. Whereas legislatures, if they get something wrong, we can hold them accountable. If the executive branch gets something wrong, we can hold them accountable, so can Congress, right? So we can do it through electoral processes and oversight processes. But if a judge gets something wrong, it's very difficult to correct their behavior. So we should be worried about entrusting judges to do those things which most appropriately belong somewhere else.
Thank you for that. And just as you were talking about the motives, as Attorney General, I'm often approached by attorneys, firms that want to bring suits on behalf of the state under our Unlawful Trade Practices Act. And when they bring it to our attention, we'll look at it and we'll be, wow, this is a very interesting issue. We'll definitely look into this. I think we can probably bring an action. And of course, there's no profit for the private sector attorney when the state is doing it. So when a state legislature or a federal government is making policy or law, there's no profit motive there because they get nothing from it. So I thought that was very interesting. Phil, if you would, and maybe I just probably teed you up by talking about that, speak to the political nature of these lawsuits and anything else that you feel is relevant to the discussion at hand.
Well, thank you, General, and thank you to RLDF and my fellow panelists. I've learned a lot just by listening to you all today. And what I'm going to try to do is synthesize a little bit of what we've heard and put them into two buckets or two paths. One is the legal theories that people have been talking about in terms of the public nuisance legal theory. And then the second are some of the practical political issues which Donald just talked about and kind of expand on that a tiny bit. From a legal perspective, this idea of public nuisance is really an attempt to try to use the court system to solve this social or political issue. And it's an effort that frankly started in the 1960s and 70s, and as Walter was saying, kind of took hold in the 90s with the gun litigation. It's never been successful. But what they've tried to do, the plaintiffs in bringing these cases, is they take what look like traditional elements of a public nuisance theory and then just put them aside. And so they basically want to say that these laws and these lawsuits stand for the premise that if you make a product that you were aware of the risks that those products might have downstream, yet you continue to promote and sell your product anyway, and then those risks manifest themselves downstream regardless of whether it's your fault, causation, product ID, any of those things. You were in the industry, then you're liable for whatever that downstream impact is, and here obviously we're talking about climate change. And so that's not what the law has ever been. It's not what public nuisance law is, or as I said, or has ever been. It's not tort law, because that doesn't give notice. It doesn't give any kind of standards for conduct. It simply says, you made it, you knew there were risks, the risks manifest themselves, you pay for it. And so that's why the courts have been throwing these cases out by and large for the past 25 years. But as I think Donald was saying, that when you file enough of these, which they have been, and obviously there's more than a dozen of these climate change suits filed in specific hand-picked jurisdictions, they're hoping that one of these judges will at least allow the case to get past that motion to dismiss, at least get into the litigation so that they can try to put pressure, not necessarily to win a case, but to try to drive a legislative or policy result and get to where they want to get to the policies that's their political agenda. And so, going back to where this litigation started, which was really in 2003 when AEP, or 2004, I think, when AEP versus Connecticut was filed. There were 4 climate change suits at the time. And the attorneys general and the lawyers and the activists who were bringing those lawsuits were fully open about what they were trying to do. They wanted to use litigation and the threat of liability and the threat of discovery and all that goes along with it, and the costs of big mass tort litigation to drive the industry to the negotiating table in Congress or with the regulators. And they were very open about what it was. The case, AEP, was the one that most people know, went all the way up to the Supreme Court, and Justice Ginsburg wrote for a unanimous court that that's not the role of the legislature. The technical legal hook was displacement, that the Clean Air Act had displaced the federal common law in this area. But if you look and you read the opinion, it's all about institutional competency, and for all the reasons you heard before, why courts are not the places where you want climate change and energy decisions made. Because there's so much that goes into deciding national energy policy. There's affordability issues, there's national independence issues, and in technology, all those things that legislators are trying to figure out. Courts can't do this on a case-by-case or ad hoc basis, which is what the court said. And so at the time, there was a case in the Ninth Circuit, Kivalina, that was being heard right after AEP. And they said, yeah, I know that, and the court said, that, look, we recognize that this case has slightly different, it's presented in a slightly different way, but if the Supreme Court said that these cases are not for the court to decide, then it's not, and we're dismissing this. And so that's what the Ninth Circuit did, and then in the Comer case in Mississippi, followed suit as well. And so the people who wanted to use the litigation to drive climate change policy got together right after AEP versus Connecticut and said, how do we figure out how to repackage this litigation so that we can try to get around AEP? And so they had this meeting in La Jolla, California, and anyone who's anyone in the litigation attended, and they came up with ways to try to get around it. So they said, well, that was federal common law public nuisance. We're going to file state common law public nuisance. There they went after the utility companies, which were the users of energy. Now we're going to go after the makers of energy. They were, that was, public entities. Now we're going to, or states. Now we're going to have counties and localities. They tried to come up with all these different combinations and permutations, and then filed, these dozen or 14 cases around the country, just to see what would, if anything would bubble up, if anything would stick. And so far, we've got, a district court ruling out of, in California, the Oakland and San Francisco cases, and district court ruling in New York that have said, no, these are the same thing as AEP versus Connecticut. This is old wine in new bottles. And so they've dismissed it on substantive grounds, and now those are up, obviously, in the appellate courts. And then there's a bunch of other cases that are still in procedural issues about whether they're going to be heard in a federal or state court. Those are all up on appeal. There's applications for stay and all that to try to figure out, kind of the process of how they're all going to go through. But at the end of the day, I am hopeful that the federal court system will look at this, will decide this isn't the appropriate use of tort law, this isn't the appropriate use of the courts, and just like they did in AEP versus Connecticut, say that they're and dismiss the cases and say this shouldn't really come out in any other form. And so hopefully that's what we'll see. How long it takes, I don't know, but it's a common tactic to use the courts to try to get a policy agenda through, and we're just going to have to see kind of where this takes us.
So I want to throw out the first question as I'm listening to all of you talk. One thing I'm thinking, I'm putting on my Attorney General hat. What should, as an Attorney General, what should the Attorneys General in the states that want to be the chief litigator for their state and not have to manage literally a bunch of feral cats, right, in the form of municipalities bringing their own lawsuits when the state is trying to bring a lawsuit for all of its citizens, including the resident citizens in that specific, because we have the same constituencies. What would, if all of you could put on policymaker hats and you could go and lobby the legislatures or the federal government, what is an alternative fix to this dealing with the municipal litigation? Is it banning it by law, or what fixes would y'all recommend?
So I think that goes to the heart of the issue here. I mean, there is a problem that needs to be solved, and so climate change is something that we as in the policymakers need to get around and try to figure out how to do something about. And the National Association of Manufacturers that I work with is very much, and they've put out statements, we're all in on trying to get solutions. But those solutions have to be based on innovation and technology so that we can figure out how we're going to source energy more efficiently with less impact on, or fewer emissions, and how we're going to use energy more efficiently with fewer emissions. And we need to have policies that incentivize and help create that kind of innovation and that kind of technology so that we can take on this problem. That happened in the 1970s after the oil crisis when Congress and the policymakers doubled down on coal. They said, we want to have more energy independence after the oil crisis. We're going to use a lot more coal because we have a lot more of that in the United States. And traditional emissions that got regulated in the 70s and 80s reduced those traditional pollutants significantly, while use went up. And so we need to figure out how to have that same solution here. Innovation, technology, working together collaboratively, not filing baseless litigation and trying to divide. We can't litigate our way out of climate change.
Any other comments on that question?
I think that public education is important about the institutional roles that courts versus legislatures versus the executive branch plays. And I think that can go from, the attorney generals can be involved in helping that, but so too can the legislatures themselves, saying, look, we've got this. I know that you think we're going a little too slow, but it really is our role. And to the extent that you ask courts to do something more, it's going to intrude upon our ability and our flexibility to do what we want to do and what can be effective. And so the more that education can be pushed forward, I think it would help change the climate that leads us to look to the courts far too often. The second thing I think is that I do think that attorneys general need to be careful about how often they themselves use courts to try and solve problems. So there are a lot of precedents for this kind of litigation being driven by state or municipal entities in a variety of spaces where we now see that this becomes accepted. And so I think some caution on the part of anyone in a governmental role who has the ability to decide whether or not to bring a case, think about whether or not it fits a constitutional model that you would like to defend on a across-the-board basis.
I would add, if I could,
Yeah,
particularly for state officials and state attorneys general, if you look at these cases, some of them involve very innovative, what you might call funding models. Some of them are on contingency fee basis. Some of them have private counsel who are effectively seconded to governments and then exercising the government's power. There are some very interesting incentives that are involved in the way these cases have been brought. Sometimes you have nonprofit activist organizations that are placing attorneys with government agencies for the purpose of suing particular private parties. In many other contexts, you would think that that could raise very serious issues under state law, under the Federal Due Process Clause, under state due process clauses, and sometimes under specific state constitutional restrictions on that kind of improper incentive. And so it would seem to me that that's the kind of arrangement that at the state level, the state authorities ought to be policing within the municipalities to make sure that they're actually following the law and best practices in terms of how they fund and participate in these cases.
And finally, I would say there can be a proper role for state attorneys general when pollution is regionalized. If something is happening to the Chesapeake Bay, I'm not surprised to see the Attorney General or Governor of Maryland step in, even though Virginia also has some interest in the Chesapeake Bay. And likewise for things that are even more localized. But climate change is, of all of these different issues, the least susceptible to this. If you are talking about the rise of the oceans, if you are talking about worldwide effects, then there is not a particular state that is suffering more than other states. They are all going to suffer in various ways. And the diplomatic difficulties that already make it such a hard problem to solve, namely that there are many major industrial nations that emit and that some sort of coordination needs to be done among them, means that America needs to be particularly united. Rather than trying to bicker in litigation region versus region, it should try to develop a unified American view in hopes that something can be done in international coordination, because that's going to have to be at the center of actual worldwide solutions.
Thank you very much.
All right. General, I will add that I know you, as an attorney general, that was the sort of the basis of your question. But in many ways, that's why this litigation and what we're seeing is a rise of targeting city officials and city lawyers, because a lot of attorneys general are being respectful of the rule of law, are saying, this doesn't look right to me. But when you have thousands of mayors you can enlist, and people who are more willing to pursue an ideological agenda rather than a legal agenda, like an attorney general often is, That's why we're seeing this, the spread of locality litigation. And that's because they're finding if they can bring 15, 20, 30 lawsuits, it may not matter if it's an AG or a city of a few million people, they're going to try to use the leverage of that and the threat of that to drive that policy agenda. And so that's, I think, why we're seeing all these localities joining it.
I know that I talked to my colleagues, and the concern is that obviously as the state's chief legal counsel, we want to be able to control all litigation on behalf of the state, but at the same time, there's a political calculus because we represent, the mayors and the councils at the city, town, county levels, but we all have the same constituencies, and the attorneys general don't want to upset their constituencies, but at the same time it becomes very cumbersome to bring suits on behalf of the state when you have a dozen or more municipalities bringing the same suit. And so do you pass some type of law or rule that requires a prior approval by the attorney general, and then when you even say that out loud, you get beat over the head with home rule. And so those are just some of the political issues that the AGs are dealing with in their respective states. I want to give the audience an opportunity, because I have a few questions I could ask, but I want to give you out there at the tables an opportunity to ask questions of this distinguished panel. Do you have any questions? Yes, sir.
I'm not sure who address this to, thank you. So whomever wants to take it, Phil or Walter or whomever, but what do you think the impact of the Oklahoma ruling is and the application of public nuisance? And I understand that it's slightly more liberal than some other states, but what do you do about the public nuisance issue writ large if it's going to be applied so or ignored so liberally, in my opinion?
I think there's a real problem in that it is possible that obviously this could be appealed to the Oklahoma Supreme Court. It's not immediately clear what federal constitutional issues would restrain Oklahoma from adopting an extremely destructive reading of its own nuisance law. And so the danger has always been that the pressure from mass litigation will find a state in particular where it can develop law rapidly in the wrong direction with effects on a nationwide market. It was always if you have appropriate application of choice of law and things, it might have been possible to have a state go bad on the gun litigation that way and simply cabinet and say you can't apply your state law to gun sales outside your borders, and that might more or less work. Maybe opioids could more or less work. Climate change, it's obviously not going to work because if they declare a worldwide process to be a nuisance toward the state, then they have declared as Andrew was getting at, sovereignty over activities around the world.
I'm interested in your thoughts on the implications or potential implications of the details we're learning about this use of state attorney general offices in climate litigation, both launching investigations at the request of the tort bar to target specific entities. In 2012, the Kiva Lien lawyer, I believe, called for, quote, a single sympathetic attorney general to begin investigating private companies, but the purpose was to extract documents that would help the tort campaign. And then the seconding of privately hired lawyers to go after, it turns out, we've now learned, the same specific companies being targeted by the plaintiff's bar. So we've really published some documents this week obtained in litigation from the Massachusetts AG's office that affirm some of our worst suspicions. In January 2011, that lawyer gave a slideshow to recruit her to launch an investigation, and the slideshow was titled What Exxon Knew. And in March, at a now somewhat infamous press conference, she announced an investigation into, and I quote, what Exxon knew. So the chronology is clear that this at least influenced that decision. And the larger chronology, of course, is I think, more damning. And then specific applications by AGs to Mr. Bloomberg's group have targeted these companies, said, if you give us these private lawyers, we will investigate. And they name ExxonMobil in a few, they name the energy industry in a few. The Virginia AG even said they wanted these resources, quote, to advance the agenda represented by Mr. Bloomberg's group. So my question is, do you see any implications for these AGs, for the plaintiff's bar, for the plaintiff's attorneys, the litigants? What implications, if any? Because we know if there were an Exxon-funded Special Assistant AG to investigate the tort bar, our constitutional watchdogs might stir from their slumber, and we might hear that, wait a minute, maybe this isn't such a great idea. Do you see any implication from learning that this is how this has been operating?
I guess I'll, since I'm the only AG sitting up here, so to restate the question, you're asking what implications or effects are going to derive out of the AG's office being weaponized, for lack of a better word, by the plaintiff's bar to target certain companies or certain industries, and then use whatever that AG finds to splinter off into other suits, or even just move forward representing that state AG's office. Is that what you're?
Or at the request, we've also found of donors.
Okay.
We'll give them resources to do this as well.
Well, you know, to me, this is a political question. Somebody might have a different take on it, but my knee-jerk reaction is, you know, when I meet with outside companies that are coming in to talk to us about their industry and its impact on our state, or if they even suspect that we might be looking at them, whether we are or not, the first thing I'd tell people is that as the Attorney General, I'm doing a balancing test. You know, the test I apply in my office is the compelling state interest test. Is the issue compelling for the state to get involved, and is it actually a legitimate case on its face? And then I look at the outside counsel for that company, and I say, first off, I have a duty to several constituencies. First is to my consumers, the citizens of the state who consume your product or service. Are they being harmed in some way? Secondly, is it happening on such a grand scale that there's no other valid way to pursue this? Is there nothing else, no other vehicle we can use to for remediation? Then I also remind them that you are also a constituency. You are a corporate citizen, whether you're incorporated within the jurisdiction of South Carolina or you're doing business in South Carolina. So I have my fidelity as to the alleged wrongdoer company. So it's like balancing a plate on the tip of a pencil. I'm always constantly balancing, because I believe, as the Attorney General, that I have got to protect my citizenry, but also protect the business climate of the state. And it is a competing interest, because I believe that when companies and people come to states, there's certain climates and cultures they're looking for. A state that has a very bad litigation environment, companies are not going to want to migrate to those states. And oftentimes those companies vote with their feet. And you'll see the companies leave, and the workforce sometimes follows them. One of the reasons South Carolina got an extra congressional district during the last census, because of the migration of people into what we consider a very business-friendly state. So I think it's a political question. The AGs, you know, that are predisposed to, you know, have that view of, you know, I'm going to let plaintiffs' firms rent my badge, you know, because it costs me nothing, because they're assuming the risk and they're working on a contingency. And I'm going to give that plaintiff's firm as long a leash as possible. The question is how long will that population tolerate that, or not tolerate it, celebrate it? In our state, you know, we fancy ourselves as a very pro-business state. And evidenced by Volvo coming there, Boeing, BMW, Honda. So we're a big manufacturing state, just to name a couple. So for me, it's really a political calculation or a political implication more than a legal one. Somebody else might have a different take on it, but that is how I view. Also, the other thing I want to say is I believe that government should have 5 attributes. I believe that government should be responsible, predictable, accountable, profitable, and stable. I'll say that again: responsible, predictable, accountable, profitable, and stable, meaning that the last two, profitability and stability, are when the government is responsible, predictable, and accountable with the policies, rules, statutes, and processes it's promulgating through its legislative or rulemaking authority. It should create the conditions of profitability and stability in the private sector. So, you know, for instance, we talked about accountability. When the courts are making rules and regulations, who's accountable? At the federal level, you got lifetime judicial appointments. At the state of South Carolina, it is very difficult to remove a judge. They are in for 6 years until the legislature reelects them. There's not a lot of accountability there. And of course, predictability is out the window when you have a patchwork of judicial decisions all over making statewide, nationwide, or international policy. So that was a very long answer to a question. I don't know if I hit it directly on its head, but that's kind of my knee-jerk response to your question.
I mean, I would think, you know, it raises, I mean, prosecutors, and in particular attorneys general, wield awesome power. And they exercise very serious responsibility. And when a prosecutor pre-decides that they're going to target particular private individuals for retribution because of those individuals' industry, because of their political views, for anything other than a belief that there's legitimately been a violation of the law, I mean, that should raise enormous red flags and is very troubling and raises serious constitutional issues. I mean, we can all imagine the hue and cry if the Koch Foundation, for example, were to go to a prosecutor or an attorney general and demand that the attorney general take action, target a particular individual. Maybe it's an activist group that opposes the Koch Foundation's policy preferences. But you can imagine the hue and cry, and people would be right to be upset about that if the Attorney General, on nothing more than the basis of that request and the politics that are involved in it, decided to pursue an investigation, decided to target that company for disfavorable treatment, or anything of that sort. The only difference we have here is that the companies, individuals that are being acted against maybe don't have the sheen of being nonprofit organizations or being activists for the public good in some kind of political sense. But like all of us, they're private citizens, they're private individuals, and they enjoy the same rights that we enjoy. And if an attorney general or a lower level prosecutor can decide that they're going to focus on and investigate somebody on something other than, some other basis than what the law requires, then really we're all at risk.
Walter.
When a law enforcement official outsources prosecutorial power, he or she is outsourcing ethics as well. And it's dangerous. I think immediately of the tobacco litigation, which was one of the great ethical meltdowns of the American legal profession. It resulted in at least one state attorney general actually going to prison, and many, many other entanglements, which came to be deeply regretted by many of the responsible people involved, because they realized that they had given too much power over what the state would do. They had created situations in which the permission of private lawyers was needed in order to get the state out of various situations. And they had compromised legal ethics along a bunch of different dimensions. Now, in the years after the tobacco debacle, I heard from people at the National Association of Attorneys General, the lesson has been learned. We have been chastened. You won't see some of those practices ever again so far as we're concerned. And I wonder to what extent that is held up. I'm willing to credit that the state attorneys general still are holding back from some of the mistakes made during the tobacco litigation. But of course, they're not the only actors. Municipal lawyers, county lawyers, never went through that necessarily. They don't have the amount of institutional memory that state AG offices do. And I see them going much further out on ethical limbs, willing to do things, willing to file suits that people must have advised them would probably not be good suits. And when you have these thousands of smaller offices with powers as strong as subpoena power and so forth, you've raised very good questions. Should the state be stepping into control? Is there some other way? I don't know.
One thing is, I was a career prosecutor before I became a government bureaucrat as Attorney General. And one of the things I learned a long time ago, and you talked about targeting certain industries or companies, prosecutors aren't supposed to prosecute people, and you can insert people with company or entity. We prosecute conduct. And oftentimes I feel like when politics or profit motive enters into the ability to make money or the ability to get political acclaim enters into it, people start with a preconceived conclusion because a company has not a reputation, but because of a particular industry or an area. Guns was an easy one to go to, but they start with a preconceived notion and then work backwards from that to justify it, as opposed to follow the facts to the conclusion. They start with the conclusion and work backwards. We always try to say, okay, that's your conclusion. We're going to start with, you have an allegation. Give us something with the allegation, and then we'll follow it and see if it goes to that logical end. I don't know that every AG does that, but that's what we do in South Carolina. Any other comments on that question? Yes, sir.
Well, a separate question.
Okay.
So I'm not a lawyer here. I just represent a free market consumers group.
But you stayed at a Holiday Inn Express last night, right?
Yeah, exactly. So some of this is, I mean, I worked in property rights and some other areas, so some of this is familiar to what you guys are saying, but I was surprised to learn that in some of the certain states, like Colorado, I would have expected this in California or New York. Colorado surprised me. What are some of the other states that are doing this, or you guys have seen that this is trending towards? And excuse my ignorance or whatnot, but what are the damages they're seeking? What are they, not only the amounts, but what are they seeking? What's the end result? Where do they want the money to go to?
In terms of the climate litigation, the only state of which I'm aware that has brought one of these suits recently is Rhode Island. Otherwise, it's just municipalities. It's a number of them in California, a couple in Colorado, the city of New York, and then Baltimore, Maryland. But in terms of states, it's just the one. In the other public nuisance cases, particularly the ones that Walter's mentioned, there are differing levels of state and municipal involvement. And it gets very complicated. In terms of the damages they're seeking, well, I mean, obviously, yes, money, lots of it, billions of dollars. I'm not aware that any of these cases are seeking injunctive relief or things of that nature. But when you seek damages, when you're asking to tax a private activity effectively, what you're asking the court to do is to set the appropriate level of that private activity, because that's, of course, what determines liability. And so courts have recognized that for there to be liability as well as to calculate damages, that to reach those decisions and to arrive at those results, you effectively have to say, what is the socially optimal and legally permissible level of that activity? And so on the one hand, yes, they're seeking damages, but as a consequence of that, they're seeking to regulate these industries in energy production.
Let me add just a couple things on the damages part. They are often seeking damages for the entirety of the problem in a particular municipality. What are they saying they need in order to abate the public nuisance? And so allocation issues become a really major part of the problem here, is because you're attributing liability for the entirety of a problem to a very small number of actors. You're not attributing liability even to yourself as a municipality, who are a contributor to some of the same problems. I mean, you use energy, right? So they're going after a very small set of contributors to the climate change problem to fund the bill for the entirety of the problem in a particular area. Some of the damages are going as pure sort of past damages. A lot of them are asking for funding for abatement plans, and that's why it gets into these really complicated remedies and whether it be judicial remedies that are being asked for, or eventually some of the settlements that are discussed, are these funding mechanisms and a diverse variety of contributions to different government programs to try and solve the problems or pay for the costs that the municipalities are claiming they have to do. The last thing I'll say is that in the climate change situation, we're not really seeing the public nuisance cases, we're not seeing requests for injunctions. But in other aspects of climate change litigation, like the Juliana case, they are trying to demand that the government actually regulate in this space. And so they're trying to get court oversight and supervision of legislatures to do things that they claim the legislatures are not doing, but have a duty to do.
I can just also add to, you talk about the sort of where's the next litigation coming. There's a very well-funded and aggressive effort by, frankly, a small cadre of funders, nonprofits, and a couple law firms to try to recruit more communities to this litigation. The Manufacturers Accountability Project has been sort of detailing that. They've issued some reports over the past few months, kind of showing the money trail and the coordination and how this is really a Goliath, if you will, going out trying to get this litigation funded and expanded, and it's very interesting. So it's very eye-opening stuff to look at, and so you may want to kind of take a look at that. And I know there's some more of that's coming out, but there's like Florida has been a target. A lot of communities in Florida. Fort Lauderdale came out and said we're not doing these. There were billboards in trying to get Miami, recruit Miami to file lawsuits. I mean, literally, billboards up on the highway, file a climate change lawsuit. So there's a lot of effort being done, and Honolulu is another one that has been talked about, and the mayor there has talked about the litigation a little bit. But it's all part of this very well-funded, very well-coordinated campaign to recruit these communities to the litigation.
And let me add one other thing, is that individuals who care about this need to be vigilant and not just look at the climate change cases, because as has been pointed out on the panel here, the opioids precedents bleed into the climate change, bleed into the lead paint, all these things about public nuisance are used to prop up the other claims. And the what's next question, as Wally pointed out, right? Is it alcohol next? Is it? We already know that vaping is a big target for the next public nuisance lawsuits. So the what's next is a question that's certainly on the minds of those who are bringing these suits, and should be on the minds of those who are understanding the effects across the board, across the economy.
One more question.
You mentioned limiting principles before, and following up on this, can someone articulate a possible limiting principle? Because we've already seen copycat groups appear. There's a group that has embedded somebody as, quote, they put it on their website, as a force multiplier in the Wisconsin AG's office, and they've got San Francisco City Attorney target and so on. If this isn't addressed here, this use of this weaponization of law enforcement this way, the only limiting principle I can see is a practical one. You will never see a right-to-life chaired special prosecutor to investigate abortion providers. It's so long as it's an approved case or an approved plaintiff, approved cause. There is no articulable limiting principle that I can see. This either is acceptable or it isn't. Can someone address that?
So I'll just jump in a little bit on that, and look at the rule of law, right? And that's what this is about, the rule of law. There are laws that have conduct requirements and they have penalties to them. There are tort liability theories that have conduct requirements, elements of proof, and remedies, damages, injunctive relief abatement that are available. If any of this litigation, if any of this effort was going through any of those prisms, then we can have a rule of law discussion. We can have discussions about what the proper outcome is and whether there should be a liability and all that. There is no limiting principle when you're trying to create a defenseless lawsuit to drive a political agenda outside of the courtroom. And so with this new iteration of public nuisance theory, the way that's being put out in all these different cases, there's frankly no limiting principle. And that is what is so disturbing to all of us. And if you look back at some of the gun cases, there was the case in New York in particular said, the creativity of public nuisance litigation would be as vast as the creativity of the trial bar. All somebody would have to do is figure out how a product was made or sold and somehow cause injury, and a public nuisance lawsuit would be born. I mean, they got it. The courts got this back 15, 20 years ago during the gun litigation. But we're in a different political time. There's a lot of frustration. It's a lot more polarized. And there's a lot more judges that are saying, well, if nothing's going to happen in this area, then I'm going to take it on. Damn the rule of law. And so that's, I think, what we're seeing, and it's unprincipled. And from those of us who are lawyers and actually care about this stuff, it's pretty scary.
Phil stole my thunder. I was going to point up and say, this is the limiting principle that we should live by. That was a good catch. I need to wrap up the panel discussion. Great thoughts from all four of our panelists. Let's give them a round of applause. And let me close by saying this. I'm wrapping up the panel discussion, but this is not intended to wrap up the discussion, both today and the days to come, because this is an ongoing issue. It's going to be around for a while, and we need to be getting in front of it. So I think there's going to be a meal served here in a few minutes. If you have questions that didn't get asked or you didn't feel got addressed by me or the panelists up here, please talk to us after we adjourn. And again, I want to thank everyone for attending today. I want to thank you for being engaged, being thoughtful. This has been incredibly informative to me as an Attorney General and a policymaker in the Attorney General's office. I will certainly take it with me when I speak to my colleagues around the country. I appreciate the four of you for making yourselves available and your experience and expertise. And again, I want to thank the Rule of Law Defense Fund, Pete Bisbee and the staff for putting this event together. For without you, we would not be able to have these thoughtful discussions. Thank you all.